Welcome to Rapid Fire Wednesdays, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in our San Diego office, and I'm joined as always by Miki Matrician, co-managing partner of our Boston office. How are you doing today, Miki?
I'm well. So good to see you.
Good to see you too. So this week we are going to talk about worksite enforcement actions related to I-9 compliance. And, one of the reasons that we're doing that is we were just together at the AILA Fall Conference in Boston. So it was really awesome to see you last week, Mickey. And it was really a beautiful fall time in Boston and so much fun to hang out again in one of my favorite cities, one of my former homes. So, Mickey, you spoke on a panel about managing ethical conflicts under a new administration in employment based cases. And our partner, Dan, spoke on a panel about the governmental use of AI and what we know and how to prepare. And then the panel that I spoke on, we talked about I-9 compliance. And it was an interesting fall conference because we had four separate tracks, and a lot of it was focused on worksite and enforcement compliance and AI and a lot of great, relevant, really timely topics. So, can you tell us a little bit about your panel and then the main points of interest for HR and global mobility professionals?
Yeah. So my panel was about how, under this administration, there have been significant shifts in immigration policy and enforcement, and how that creates a really challenging environment for business immigration. And so we talked about critical ethical considerations that attorneys face and offered up some proactive solutions and strategies for attorneys to, help them navigate this landscape. So the audience was immigration attorneys, but to your point, Kim, there were definitely key takeaways that translate over to global mobility and HR professionals. And I would say that the top three are: staying vigilant on compliance is really critical to avoiding legal risks. Planning for workforce continuity is important and not just case by case processing. And then preparing before a crisis or worksite enforcement before it happens is so important. And part of it is to clarify stakeholder roles. And I know the hot topic, as you say, of the conference was ICE enforcement actions, especially with what's been happening in Washington, D.C., Chicago, Boston, and LA, just to name a few.
Yeah, that's right. There's so much going on. And with the billions of dollars that ICE received from the one big bill, they have a lot of resources to conduct more worksite enforcement actions. And there are several different types of enforcement actions. Some of them we hear about a lot in the news, some of them not so much. But Mickey, what are some of the types of these actions that, HR and global mobility professionals have probably already witnessed, been involved in, or could potentially expect to occur at their work site?
Yeah, well, there's a knock and talk in which ICE agents and or auditors just show up at an organization and want to chat about I-9 compliance. The image program, which is the ICE mutual agreement between government and employers, and they act really friendly, right? And with a knock and talk, an employer is not obligated to speak with the agent and or the auditor. So the company rep at the front desk can just say, "Thank you, but we're not interested." Or they can call the company representative that's responsible for speaking with government officials, maybe someone in HR or legal, who can then let the agent or auditor know that they're not interested. So they can smile and just send them away. And there's also the I-9 Notice of Inspection, which is issued by ICE, Homeland and Security Investigations, or HSI. So typically, it would be an agent and auditor that show up at the work site. But lately, there's been some instances where several officials that might show up, and some can, be standing next to entrances and exits in the event employees run away. So that's quite concerning. There's a mandatory minimum period of 3 business days that HSI is required to provide the employer to turn over the I-9s. So never waive the 3 business day period. The notice of inspection may also be accompanied by a questionnaire and or an immigration enforcement subpoena asking for additional documents such as payroll records, I-9 policies, etc. And those documents don't need to be turned over within the 3 business day period, and the employers may negotiate for additional time as well. So recently, HSI served hundreds of restaurants in Washington, D.C. with notices of inspection. And because a company may potentially have only 3 business days to turn over the I-9s and any supporting documentation, it's important to have a plan in place ahead of time and to conduct at least a mini audit, which includes making sure there's an I-9 for every active employee. And we recommend doing this internal audit with an experienced attorney so that it is attorney client privileged. And if a company uses an electronic I-9 system, the HR team that oversees the I-9 process may want to reach out to a provider in advance to make sure that they know who to contact and how long it'll take to obtain the additional documents needed from the provider that are requested by HSI in the notice of inspection. In addition, we recommend that HR teams make sure that they have properly completed the re-verification process for employees that have limited work authorization. And it is even more essential now with the termination of various parole programs and TPS designations for HR teams to review the work authorization of those whose temporary work authorization may have been terminated earlier than what was referenced on the EAD card that was provided. Kim, what are some of the other enforcement actions that we have been seeing in practice and in the news?
Yeah, well, Mickey, there have been raids that have been published in the news. And keep in mind, it's the fact that the raids are not notices of inspection, right? So raids are the results of investigations that have been conducted by the government, typically by Homeland Security investigations. And the government goes and requests from the court a warrant to obtain documents, equipment, and or people, i.e. workers, from a specific work site. So the most recent raid that garnered a lot of attention was the raid in Georgia of the Hyundai facility. And the warrant for this raid only listed 4 people, yet ICE and other government agencies that were involved in this big raid detained over 400 individuals, most of whom were citizens of South Korea. So keep in mind that South Korea owns Hyundai. And, that plant that was raided was a battery plant. Based on the information that we received, some of the individuals detained may have actually been lawfully present in the US based on a very specific and narrow business visitor classification for after sales service and installation and training. So there's a very narrow category that allows people as business visitors to essentially engage in productive employment in that they're assisting with the training or the servicing or installation of equipment or software or something that was developed and or built abroad. So that was the latest that we've seen. It was a tremendous raid, right? Over 400 individuals that were detained. And there were about 300 South Koreans that have been returned to South Korea. So for HR and global mobility professionals, now is the time to, review workplace enforcement preparedness plans. As Mickey mentioned, conduct an internal mini audit to at least make sure you have an I-9 for every active employee hired on or after November 6th of 1986, which I know is a long time ago. So there's a lot of individuals that weren't hired before November 1986. So most of those I-9s will be required to be turned over to HSI if there is an audit. And then, you can even do a larger internal audit together with counsel in order to essentially do a dry run in case ICE were to knock on the door. And then also coordinate closely with legal counsel to be prepared in the event of any worksite enforcement plan. So know exactly who to contact, who at the front desk is going to answer, the door and who they should reach out to within the organization to be that point person. If there's an NOI, the document is usually turned over. If it's a raid, an attorney might not be able to get there in time, but an attorney can always be available on the phone or via FaceTime in order to kind of watch and see what's happening or listen to it. And then the other thing that we recommend is to review I-9s to determine if any employees have been impacted by the termination of TPS programs and or the Cuba, Haiti, Nicaragua, Venezuela parole programs, which we call CHNV parole programs. So there was just a court order last Friday while we were at the conference that has required the government to post additional information on the USCIS website about TPS for Venezuela. So we'll break that down a little bit later because there's a lot to break down on that, a lot to synthesize. So stay tuned. More information will be coming on that, but it's something that employers really should be aware of and be very vigilant about re-verifications.
Yeah, and this is also an opportunity for employers to proactively assess visa dependent roles and consider any necessary adjustments to their talent acquisition and retention strategies. And I know we're always, working with our clients to support with compliance planning, and workforce impact reviews, and internal communications as well. And, I think it's also really important for companies to ensure that their immigration programs, have a structure and it's centralized and, avoiding the things like managers piecemeal giving permission for their foreign nationals to travel and things like that, for example. All such travel does need to be vetted by appropriate HR and global mobility professionals together with immigration counsel. And it's important to ensure that foreign nationals are entering the US with the appropriate visa classification and performing the appropriate activities while in the US. And failure to do that might have a significant negative impact on the company, especially with any foreign nationals entering the US for business activities.
Yeah, it's really good advice, Mickey, especially since, what we've seen with Hyundai and various other situations. We don't want companies to be in a situation where some employees come into the US and essentially can have a negative impact on the ongoing program for an organization. And I think with those tidbits, we're going to wrap up this week's Rapid Fire Wednesday. And we will continue monitoring legislative, regulatory, as well as court developments, and we'll also review agency guidance and provide updates in future episodes as we hear of them. So, as always, for the latest updates to the immigration landscape, please follow RWR Immigration on LinkedIn, as well as Mickey and my personal profiles for breaking updates and insights. We also transcribe each and every Rapid Fire Wednesday episode and share it through our weekly newsletter, which you can subscribe to. The link to subscribe can be found in the video description. So thank you for joining us, and we'll see you next time. Great to see you again, Mickey.
Good to see you too, Kim.